Good morning, everyone. Thanks for joining us this morning for our webinar on the KCMO new ordinance that we'll be following starting June 1st of this year. I'm Robert Long. I'm the president of Landlords, Inc. And we're bringing this webinar to you in partnership with Kansas City Regional Housing Alliance and our other partners in the industry. I'd like to introduce Stacey Johnson-Cosby, who is one of our board members on Landlords, Inc. and also a founding member of the Kansas City Regional Housing Alliance. And she will be moderating our webinar this morning. Stacey Johnson-Cosby, it's all yours.
Good morning. Well, thank you, and good morning, everyone. Thank you for joining us. And as Robert said, that I chair an elite alliance of property owners, housing providers, and we are all working together on this effort. And we all worked in order to get some of the provisions changed in the Bill of Rights that we have before us now. And so we were very successful in getting the worst part of that killed. And I'm sure that our speakers, Bob and Dan, will talk a little bit about that when we talk about what remained. But the most important part is that we were engaged as an industry. We came together with one voice to fight against some of the things in the bill that just didn't make sense for our industry. And there were several of us that were engaged, and we will do this going forward. So we're still out here, but several people that were engaged, and we ask you to stay connected with them through Facebook pages and through these various organizations. That's where we get our word out and our message out. And those groups are MARY, which is led by Kim Tucker, the Mid-America Association of Real Estate Investors. She has a Facebook page, and they meet monthly. Winvestors, led by Michelle Winberry, and they meet every Wednesday morning, another group of investors. And Bridge Real Estate Investing Meetup with Nathan and Abby, and they meet, and they're on Facebook, and they have regular meetings. And the Kansas City Regional Association of Realtors, which is over 10,000 strong, led, our efforts here led and represented by Derek Ramsey. And the Landlords of Jackson County, and then again, our alliance, the KC Regional Housing Alliance. And so anyway, the two attorneys that you're going to hear from today, we were engaged hands-on both of these pieces of legislation, whether it's the Healthy Homes Rental Inspection or the Bill of Rights and the accompanying ordinance. So we were at the table working on those, and there will be more to follow, so we'll be engaged. But we thought it was important to make sure that all of the landlords, even those who are not on this in this workshop today, that we get the word out far and wide, because like Robert said, these laws go into effect in June. And if we are not complying, you better believe that somebody's out there watching. So we need to make sure that we stay in compliance as an industry. And so we're going to get started. We're going to talk about the ordinance, the Healthy Homes Inspection Ordinance that came into effect 2 years ago. And there are a lot of us out in the industry that are not even aware that this is in effect and that we must register our properties. And we want to make sure we catch us up on that. And we will have an opportunity with both of the speakers at the end of each of their sections to take maybe a few questions. And then at the end, we're going to come back and answer any questions that anyone may have. And Robert will be monitoring questions, and we'll have those in the Q&A. And so we will begin this morning with Dan, and we're going to talk about healthy homes, and then he's going to also give us information about the courts and evictions. And let me share a little bit of information about Dan, because like I said, that they are both attorneys that have been active in our market for several years, and many of you know them and have worked with them. And so a little bit about Dan. He has a BA in philosophy from University of Texas, and his JD is from Southern Methodist University. He's been practicing landlord tenant law in Kansas City for about 22 years. He's a past president and a current board member of Landlords, Inc., which is our sponsor today, and a founding member of our KC Regional Housing Alliance. I'll turn it over to you now, Dan.
Morning, and welcome to this webinar. Hope all of you are successfully navigating the COVID shut-in. As you can tell, neither Bob or I have had a haircut in quite a while.
Speak for yourself.
This morning, I'd like to first start out talking about the federal moratorium on evictions, which hopefully most of you have heard about. Probably few of you, including Bob and I, might not entirely understand, but I'll go over it and give you the benefit of our wisdom. To be covered by the CARES Act, which was the federal law with a moratorium on evictions, your property needs to either participate in a housing program of the Violence Against Women Act or the Rural Housing Voucher Program, or if it has a federally backed mortgage loan or a federally backed multifamily mortgage loan. And many of you may not know whether or not your mortgages are covered by that, but your loan servicer should be able to give you that information. And even if it wasn't backed by that, it may have been sold to someone who does have it insured federally. So check with your servicer. And the reason that's important is because if you're not covered by the CARES Act, then you're free in Jackson County to file your evictions. If it is covered, then there's several restrictions, and we'll get to what those are. The first of which is you can't file an eviction for failure to pay rent for 120 days from when the CARES Act went in. So basically till July 25th, you're not allowed to evict for failure to pay rent. The more confusing aspect of this law comes for those evictions that are not for failure to pay rent, which would be for criminal activity. They've moved people in, they have pets they're not supposed to according to the lease. Where does that leave you? And according to the CARES Act, you cannot require that the tenant to vacate the covered dwelling unit before the date that is 30 days after the date on which the lessor provided the tenant with a notice to vacate, which is to say you have to give a notice 30 days in advance of the eviction. However, you may not issue that notice until July 25th. Now, the way I read this was that they were trying to prevent evictions for failure to pay rent, and they didn't want people to non-renew leases in the middle of the pandemic, and they didn't want people to terminate month-to-month tenancies. And I think that's the way Jackson County is reading it. But speaking to some other attorneys, their opinion was that you can't do any of those types of evictions because those all involve a notice to vacate. So I went back and looked at the statutes, and in Missouri, an unlawful detainer action, which would be for a breach of the lease, does require a 10-day notice to vacate given to the tenant. So technically that would be in violation of the law, but I can't imagine that the intent of Congress was to allow criminal activity to not be evicted until July 25th. Okay, let's see. There are two evictions that are not non-payment of rent in Missouri that are available to a landlord that don't require any notice, and that would be the expedited eviction, which is sometimes called the emergency eviction, and that is when the tenant is likely to physically injure another tenant or the lessor, when the tenant is liable to cause damages to the unit exceeding 12 months rent, or when there is various types of criminal drug activity going on or near the property. The other type of eviction that doesn't require a notice is when the lease has a termination date and there's nothing in the lease requiring the landlord to give affirmative notice that it won't be renewed and there's no automatic renewal. Those types. And I would imagine that's something they wanted to cover in the CARES Act, but the way it's written, that is not covered. Also, another issue that has arisen with this is that it doesn't appear that there's a sunshine date on the notice requirements, which would mean until Congress readdresses this issue, the 30-day notice requirement would extend forever. And that's currently contrary to state law. And so we're going to have to see how the courts are interpreting that. Okay. So now various counties, let's go over it. Jackson County and many of the other counties are requiring landlords who file evictions to file an affidavit stating either that they're not covered by the CARES Act or that the eviction was filed prior to the CARES Act taking effect and that they're not charging any of the prohibited fees, late fees, penalties, or other charges related to non-payment of rent. The way they wrote it is for any of those things, but my interpretation of it would be that you're allowed to charge late fees and things up until March 27th when it was filed, and and your affidavit is stating that you're not charging late fees or penalties after the March 27th date. And then the third category is that the premises is a covered dwelling by the CARES Act, but the plaintiff does not seek possession of the dwelling based upon the non-payment of rent or other fees. This would indicate to me that they think that unlawful detainer actions could go forward, which is why I think they're reading the CARES Act the same way I initially did. But this definitely warrants a discussion with your attorney, what risks are involved, and before filing an eviction.
And we had a question from Alicia Sazik. What if the tenant was in violation of the lease agreement and late on rent before the shutdown?
If you took action on that before the CARES Act went into effect, then it would not be, then the eviction could go forward when the county gets to it. If the action took place before, but you haven't done anything about it, then it would be covered by the provisions of the CARES Act now.
Thank you.
Okay, so what Jackson County is doing, many of you know that there was no moratorium on filing cases, but they were continuing all the cases because they didn't know how to hold hearings and things. Well, they've started having telehearings, and they're anticipating, I think next week, opening up the courtrooms to 10 people, limited it to 10 people at a time. The elevators in the courthouse, there's only 2 working elevators, and they're only going to be allowing 2 people in the elevator at a time. And it's roughly 16 stories up the stairs if you're going to walk. So my encouragement would be to figure out how to do the teleconference or get there very, very early. Let's see. I mentioned the affidavit. And they put a ban on enforcing writs of execution, which is the set outs with the sheriffs, until June 1st. They've extended that. Cass County says that they're not putting off the set outs or anything, but they haven't been issuing court dates in I think the earliest one was the first week in June. At least that's what I've been experiencing. So hopefully in June they'll be proceeding as they normally do. Let's see. Wyandotte County, as far as I know, the last I've heard is they haven't figured out how to do telehearings, and they're not allowing in-person hearings, so they haven't been setting any court dates or issuing any summonses at all. And Johnson County has been setting court dates in June, and they're going to attempt to have multiple smaller dockets and teledockets, I think. And then they're also, the judge is going to be allowing COVID as an excuse for failure to pay rent. I don't know that anyone's had any dockets yet, and he may be talked out of that. But I think that was his position the last time I heard. Any of the attorneys that are listening have more current information on Johnson County, feel free to type that into the question area. So now I'm going to turn to the healthy homes, which many of you should be familiar with now. It's been in effect. It's been the law for 21 months. You're required to register if you have a tenant, and a tenant includes anyone who rents from you. It also covers anybody that you're involved with a contract for deed if the deed has not been recorded with the county. The fees for the healthy homes are $20 per unit application fee, and a $20 annual fee for each unit. So at this point, you should have paid last year, and then the $20 application fee and the $20 per unit fee, and then just the $20 per unit fee this past December. It has to be paid by December 31st, and then you will get your permit, which after 21 months, they still have not issued a single permit. But that's because this is really just a way for the health department to fund itself. But that's my opinion.
I have a quick question for you, Dan, if I could.
Sure.
So if there's someone sitting out there today that has not registered their property or any of their properties at all, And if they go on site to register now, will they be penalized?
Okay, the act or the ordinance does call for a 10% per month penalty fee, but we've had anecdotal evidence that if you call in and say, hey, I just found out about this and I want to get in compliance, I haven't paid before, I'm sending a check with my registration, that they have not been pursuing any late fees. But that's not a guarantee, and that's not probably official policy, but that's what we've been hearing from people.
Right, and I know at some point that we, and Robert may have this information, at some point we tracked how many landlords were in compliance that had actually registered. Do we know that or have an update on anything?
The health department itself has said 92% compliance, but I don't think that they have any accurate numbers on how many landlords are out there.
Okay, and at some point they'll probably start chasing us down, but you're saying so far they haven't yet.
That's correct. They haven't even issued the permits yet. So I think if money's coming in, they're happy, and they're not pursuing anything else at this point.
I would add, though, that for those who haven't registered, it's a good opportunity to kind of get in before they become any stricter on charging late fees and stuff like that. So if you've been avoiding it and are now concerned about complying, go ahead and take the shot and get yourself registered. Okay.
The ordinance provides for 3 types of inspections of residential rental property. The first is complaint-based, which is basically what it says. If the tenant has a complaint and they call in, then they'll go out and inspect. The second type of inspection is an annual random inspection that's to be determined by the director of the health department, how many they'll do and where they'll do them. And then the third type of inspection would be for landlords or owners who have multiple violations and compliance problems. Those properties can be targeted for inspections for not necessarily annual inspections, but just random inspections.
If I can jump in again too, Dan, I think it's important for people to know that unfortunately, when we fought against this, we wanted to limit the power that the health director has. One of the things in the ordinance that he's allowed to do at any given point is to change the percentage of inspections. So at this particular time, it is based on complaints from tenants, but at any point, he can turn around and say, we're going to have, 15% of the properties inspected, 50%, or 100%. So that's something we need to be aware of. And I'm wondering and we're trying to keep, as an alliance, we're trying to keep in close touch with that department to make sure they know that we are indeed in compliance as an industry, so that they don't feel the need to ramp it up and require testing amongst any, of us outside of complaints by tenants. So we're trying to maintain that relationship with them so that they know we are indeed, of course, responsible housing providers.
That's correct. And they, the first year they had 3 inspectors, and their plans were to hire 3 more. And they were holding monthly meetings, which someone from Landlords had been attending. But they've since stopped holding those meetings. So we're not getting as much up-to-date information from the health department as we were. But obviously with 6 inspectors, you're not going to be able to cover complaint-based inspections and annual inspections. So as of now, there have not been any annual inspections. Every inspection that's been taking place has been a complaint-based inspection. Okay, Robert, can you put up the retaliation? So under the Act, a landlord is not permitted to retaliate against a tenant who has filed a complaint. And what they consider retaliation would be that you can't evict or fail to renew a lease based on the tenant's complaint. You can't shut off a tenant's utilities or services due to a complaint. You can't charge the tenant for any of your registration fees, your late fees, your reinspection fees. You can't. According to them, you cannot even pass that through. On the following lease, you can't put that into your fixed costs and adjust your rents that way. You can't waive any of the tenant's rights with any provision within your lease. All of those things would be considered retaliation under the ordinance. So the way the system is working now, okay, you can take that down, Robert. It only showed 2 of the bullet points. I don't know if you can see that. The way it's working now is a tenant would call the health department and make a complaint, and they're not required to notify the landlord beforehand. And the department would send out an inspector, and the inspector would look at it and determine what's wrong with the if there's anything in non-compliance with the unit. They would then contact the landlord, let him know about the deficiency, and work with the landlord on how much time he needs to make that repair, make sure that the repair is going to be made in a timely way. And then once the repair has been made, the landlord would contact the inspector, and the inspector can either come back and inspect the property, at which point the landlord would be charged $150, or, and what we've been recommending, and it has been working out successfully, is that the owner take pictures of the repair or send in the invoice, the paid invoice from whatever service person you hired to make those repairs. And generally, that has been sufficient for the case to be closed, and the inspector hasn't been doing the reinspection, and so people have been avoiding that $150 reinspection fee. In the event that you don't do the repair, or the repair isn't done to the inspector's satisfaction, they would give you more time, have another reinspection, and there would be another reinspection fee as well. All right. They can, under the act, they can suspend your permit without notice. And there's a slide for that, Robert. Under 4 conditions. If there's a life-threatening condition on the premises, they can suspend the permit. If you ignore or refuse to correct a violation, they can suspend your permit. If they find violations of the ordinance on the property, they can suspend the permit. And if you interfere with the director or an inspector's duties, they can suspend the permit. They haven't issued a permit yet, so I don't know how they would suspend it, but basically suspending the permit would mean that they are shutting down the unit and removing the tenants. And to my knowledge, they haven't done any of that yet. They're treading very carefully, and I think it's because they know this won't survive too many legal challenges. So they've been very helpful in working with landlords on the cases that we've seen so far. If your permit is suspended for some reason, they do charge you $300 to reinstate the permit. But like I said, they haven't issued any permits yet, and they haven't, to my knowledge, they haven't suspended any permits yet. The permit can be revoked with a hearing. They're required to give you a hearing. And in order to revoke with a hearing, there has to be serious or repeated violations, or that there's been a suspension of the permit for more than 90 days, or there has been an assault or repeated interference with director or the representative, which would be the inspector, or that there's been a failure to comply with a permit suspension order, which would be they suspended the permit and moved the tenant out, and the owner had moved a new tenant in. That would be a failure to comply with the suspension order.
And then do we have any questions before, I know you're wrapping up that section, any questions before we move on to your next section? Anything, Robert?
Yes, we have a couple. Frederick asks, how about asking for inspections requested by landlords for tenants who are not fulfilling their responsibilities to clean and maintain properties?
Great question.
The ordinance is not set up in any way to put any restrictions on a tenant. There's no they There's no findings of retaliation when it's clear that a tenant made a false claim. They don't make a determination of whether a damage to a unit or deficiency in a unit has been caused by the tenant, or whether it's a maintenance issue for the landlord. The landlord is responsible for making those corrections, whether the tenant intentionally created damage on the property or not. So there's really no recourse for the landlord to pursue tenants through this.
And don't think that we didn't try. We did ask about that up front, because when we're looking at this relationship, it's a give and take, and both sides should have responsibilities. And in that particular time when we were working through that, that is something that we brought up many times, that sometimes a tenant has responsibilities. It should not all fall on us. So that's something that we'll continue to inject in our conversations with the health department as we have it too, because it shouldn't all be on us.
Now, the head of that program has gone on record and said that either the landlord or the tenant can order an inspection. And they have said that if you need to document, that they will document the condition of the property. But I would be careful about doing that, because, you know, if they come out and do an inspection, as Dan was just saying, they will ultimately hold the landlord responsible for the issue. But they have said that they would document that, and you could use that if you need to.
Okay, you said you had another question, Robert?
Yeah. Seth asks, could a landlord use the Missouri Sunshine Law to obtain prior complaints made by a person who may be applying for tenancy to, in theory, screen potential new tenants?
And do we want to get to that with Bob? I see Bob's face there.
We don't.
Yes. Because we're going to be talking about who you can and can't rent to. And so that's something that I wonder if we can come back to that question. Bob, is that okay? And we'll finish up at Healthy Homes here.
Perhaps we'll refer you to your attorney for that question.
Yeah.
Okay. Anything else?
So with regards to the revocation, if your permit is revoked, you have to wait 6 months before you can request to have a permit restored. So that would be a bad thing. That would be 6 months with an empty unit. You may appeal either suspension or a revocation, but you have to make your request for an appeal within 10 days of the suspension or the revocation. And they will hold a hearing within 15 days of the request. But the hearing is going to be in front of the director of the health department. So it's not an impartial hearing, in my opinion. But like I said, there haven't been any suspensions or revocations, so there haven't been any hearings. So we don't know how those are actually going to go. So the penalties for violations of this statute are up to a $1,000 fine and or 180 days in jail. So it does have to be taken seriously. And that's just a quick overview. If you have more questions, you can contact your attorney or attend a Landlords Inc. meeting, and we frequently have sessions where lawyers attend and answer questions. So I'll turn it over to Bob.
Dan, we have several more questions in the chat.
Sure.
You know, if we can take a few minutes.
Do you want to take a couple of those, Robert, then we'll get to Bob, and then maybe come back at the end and just open it up for questions from everyone?
Sure.
Okay.
Kathy, if you need an application for Healthy Homes, you can find that on the Kansas City's website.
Right, on the health department website.
Micaiah Bland says, I will become a landlord in KC soon. My understanding that I need to register as a Healthy Home and pay a fee, but there's currently not an actual inspection done unless the tenant requests it.
That's correct. And the permits that don't exist are non-transferable. So if you buy a property, you're required to register, even if the previous owner has already registered that property for the year.
Would a business decision letter to a tenant be enough to avoid scrutiny if that an eviction and non-renewal is retaliatory?
Would a what? Could you repeat the question?
They're asking if they do a non-renewal after someone who has filed a healthy homes complaint, would a business decision letter be enough to avoid scrutiny that the eviction or that the non-renewal was retaliatory?
If there's a, well, under Missouri law, there's no requirement for any reason for non-renewal. So they would have to bring a separate action saying you didn't review, didn't renew as a retaliatory action. And then you would, at that point, have to prove why your action is not retaliatory. And if you had a valid business reason, like you were going to sell the unit instead of rent it, you were going to undertake numerous renovations, you were going to move a family member in, something like that, and that would suffice.
Thank you.
Okay, so why don't we jump to Bob Wise? We're going to talk about the current Bill of Rights that and the ordinance that is associated with that goes into effect in June. But I'll tell you a little bit about Bob first, and he has been around for a long time. I think it's 45 years, and
right.
And he says that he is now retired. He's been retired for a little bit, but he's still active and engaged. And just like Dan, hands-on engaged with us and helping to craft our position for these ordinances. He graduated from the University of Missouri Columbia Law School, and he normally speaks to property owners and tenants on landlord-tenant laws, collections, fair housing, and other related housing issues. And he was also the executive director in the past of the Missouri Apartment Association, and he serves as the executive director now of the Mid-America Crime Free, which educates landlords and property managers and tenants about crime prevention and rental housing. So we'll turn it over to you, Bob, to take us through the current Bill of Rights ordinances.
Thank you, Stacey. I thought I might start off by addressing that question about using the Sunshine Law to find out about a tenant's prior complaints and using that as part of the screening process. I am not an expert on the Sunshine Law, but let's assume for the moment, just for the sake of this question, that yes, you could get access to those complaints. The problem is that the questioner sounds like he would use those complaints as a reason for not renting to that applicant, which would be retaliation and which would be a violation. So the question isn't, can you get access to them? The question is what you would do with them. And if that's how you're planning to use them, I wouldn't go down that road. Now, to get directly to the new ordinances passed by the city, first thing I want to do is maybe clarify some misunderstanding about the difference between the so-called Bill of Rights and the new ordinance that was passed. The Bill of Rights is not law. It is what's called a resolution, which has no legal effect. The ordinance is law in the city of Kansas City. A resolution is basically, from what I can tell, a list of opinions and a wish list. The particular Bill of Rights that was passed has two elements in it. One is just a rehashing of laws that have been on the books for years and which most of you probably already know about. Things like double damages for a security deposit if it's wrongfully withheld. The repair and deduct statute, things that have been around for years are just being rehashed. The other parts are what I would call the wish list of things that are now considered rights, but which aren't enforceable because there's no law backing that up. I was thinking of a good comparison for this, and I thought of the famous John Lennon song, Imagine. It's a beautiful song, but nobody really thinks they can live like that. To give you an example, one of the rights that are listed in the Bill of Rights is that the tenants have the right to relocation assistance from the city in the event of a forced move, like a displacement on the basis of uninhabitable conditions. So this says that if a tenant has to move out of a property because it's uninhabitable, he has the right to relocation costs from the city. Now, again, that is not the law. I doubt if it ever will be, but it's part of the so-called Bill of Rights. Now, for the actual ordinance requirements, everything I'll say from this point on is actually part of the ordinance, which is law in Kansas City. The first thing that the landlord needs to know about is requirements for new leases, for new tenants. Before the contract is entered into, you must disclose the phone numbers of the utility companies. Now that started out, the original draft wanted us to disclose an estimate of what the utility costs were going to be for the year, which would do nothing but lead to lawsuits against landlords if you estimate wrong. So after some lobbying by our organizations, that was just reduced to giving the tenants the phone number of the utility companies so they can call and get their own figures. You were only obligated to give out phone numbers. You also have to give a copy of the tenant's Bill of Rights, which is going to cause quite a bit of confusion because, as I said, it lists some rights that they really can't enforce. But anyway, you do have to give them that. That's the second requirement, a copy of the Bill of Rights. And then a written description of all deficiencies in the last 24 months. Now, we've got a lot of questions about what has to be disclosed. And in the actual language, I would divide this into a couple of different categories. One, it says you have a written description of all notices of deficiencies and citations issued to the owner of the property during the previous 24 months. So when you talk about citations issued, the way I read this is just something you've actually received some kind of complaint from the city or some regulatory body that could be called a citation that was issued to you. Not a complaint from a tenant, nothing like that, a citation, a deficiency or citation that was issued. Then it says, and you must also disclose any other deficiencies prohibited under these chapters existing at the time of the notice of which the landlord is aware. So in addition to any citations received in the last 2 years, you have to disclose any violations which might exist on the property at the present time, if you know about them. That does not go back to any problem you had in the last 2 years, just problems that presently exist and that you are aware of. Now, how do you establish if you've done that? We've had a lot of talk about this as far as creating forms to show that some kind of receipt signed by the applicant that they've received these 3 notices. That can be done in a number of ways. As I said before, they have to receive these disclosures before they sign the contract, but it doesn't say how long before. So if you're having them sign a stack of documents, as long as they sign the receipt saying, yes, I've received these 3 disclosures, before they actually sign the lease, you've complied with the ordinance because they received that information before they signed the contract. And this could be done as simply as a form that says, prior to signing the lease, I have received the phone numbers, Bill of Rights, disclosures. They sign it and date it, and that's good. I've also seen, we've exchanged some forms where on the lease itself, there's a place to sign that says, prior to signing this lease, I have received, et cetera, et cetera. So
if I can jump in just real quick here, Bob, while we're on that topic, because that's going to be something that we're trying to figure out administratively how to handle. Landlords, Inc., and I'll ask Robert if he can jump in here, normally provides for their members copies of leases and applications. Robert, can you say what Landlords, Inc. is doing, how this organization is going to handle those documents for the members?
Sure. Thanks, Stacey. We have put together a standalone disclosure that addresses the utility information and provides the owner the opportunity to disclose any deficiencies, whether current or those that they've received notices for. We've also, on that, we have a statement where the applicant can find the tenant bill of rights, but we think we need to document a little more firmly their actual receipt of that. And then we can also document that again. We've updated our lease to reflect that the now tenant has actually received those items. We'll be sending those updated forms out to our members this coming week.
Okay. And also just a note on the website, on the Landlords Inc. website, there's a copy of the Bill of Rights. If someone wanted to just go on, that's available on the kclandlords.com website if you wanted to print out the Bill of Rights yourself for attachment. So that is available there.
Yeah, I've thought that in regard to disclosing the prior problems for citations in the last 2 years, it just has a written description. It doesn't have to be copies of the complaint, anything like that. So I think you could possibly even turn that into a marketing device where you can say, in the last 2 years, we've corrected the following problems, or we've made the following improvements on the property. You know, we patched a hole in the roof and we put on new paint outside, you know, so that could almost be a pro. But anyway, next topic.
Bob, we have a question. Lauren asks, if the property is leased by a leasing agent or company, would it be the responsibility of that company to provide that information prior to the lease start date?
Okay. This is good. This is a good question, and it's something that's addressed in the ordinance. The ordinance talks in terms of the owner, but the owner is defined as the person who has legal title or who is in charge of the property or any of their agents. So if you are the property manager or an agent of the property manager, you are covered as an owner in the ordinance. Now, I think it would probably be up to a contract between the owner and the manager, management company, to say, here's who's going to be responsible for doing all of this. So, yeah, the answer is yeah, the owner's responsible, the property manager's responsible, and they need to have some kind of agreement between themselves as to who's actually going to be doing that. Does that answer that?
Yes, thank you. Another question's come in from Frederick. Does the deficiency and the tenant bill of rights requirements extend to existing tenants or only to new tenants?
I believe the new ordinance applies to leases entered into after the effective date of the ordinance, which is June 1.
So
right now, this ordinance doesn't apply to anybody. It doesn't apply to any leases you have in effect now. The lease you sign on June 1 is covered by the new ordinance.
any other questions, folks?
I have one. So Bob, help me understand. So here I sit today, June 1st, I'm going to have a property available and I want to be in compliance here. So my first step when I say, okay, this property on 123 Apple Street is available, I'm filling out my form about the deficiencies, whatever I've created to fill out. My sources, where do I go to look? Again, tell me where to find the information. And if you can repeat again, what exactly, which types of deficiencies do I need to list?
Again, you would list any, go back 2 years, 24 months.
Okay.
List anything that you've gotten a citation for, if any.
From the city, specifically.
Because all notices of deficiencies and citations issued to the owner. Okay. Then you also have to list any present problems on the property that you're aware of. Any problems which would constitute a violation, such as not having functioning heating or air conditioning or utilities or whatever. So any problems you know of now, you have to disclose, and anything you were cited by the city for in the last 2 years. Okay?
Okay.
All right.
And then those citations, would they include citations that tenants cause? For example, if a tenant has, repeatedly parked, and it's not a deficiency, I guess, but they parked on the grass, or they have a couch on the porch, or if there's something inside the house that the tenant caused, and yet the citation, of course, comes to us, do I need to list that?
I would say so. You received a citation for it. Now, that doesn't say you can't provide that information you just talked about. It just says, this is your written description of it. You can say, yes, we got a citation for such and such after the tenant did this to the property.
And
So, you don't,
that's a good teaching moment to explain to your tenant, your new prospective tenant, that won't be tolerated.
And to make sure it's covered in your lease too, so.
Yeah. But you really have quite a bit of leeway as to how you disclose this, because this is just your written description of the citation. So that gives you a little leeway to
Okay, here's a couple more questions.
And let me follow, if I could, real quick, Robert. So the backup to that is if you are cited, then if the tenant says, hey, this landlord did not tell me about this, I went and dug on the city's website and I found out there was a complaint, about this. And then I'm thinking of how to defend myself in the event that a complaint is made against me, and what the best things I need to do to be able to defend myself. I'm just thinking along those lines. Okay.
All right.
Okay, so Carrie says, this is a great question, Carrie. Are citations and deficiency notices that must be disclosed limited to the unit being leased or the property as a whole? Thanks, Carrie.
It looks like the unit itself, because it says any citations issued to the owner of the property, of which the rental unit is a part.
Right.
So that would be the entire property. So if you've got a 20-unit building, 50 units, and you've got a citation anywhere in the building, you'd have to disclose that, because that's part of the property of which the rental unit is a part. And the ordinance describes rental unit as that specific unit, and rental property or rental premises as the entire property. So one unit is a rental unit, a dozen in one place is, in one structure, is a rental property, to use the language of the ordinance. Okay? All right. Some of the other important issues that we had to address when this ordinance was pending, one of them was the so-called just cause eviction. And what they wanted to do here, and this is part of a national movement, almost none of these ideas came from any local groups. This is part of a national movement. And what just cause eviction is that you cannot evict somebody or even terminate a lease without some kind of legal reason. They have to be in violation of the lease, or not paying or something. You can't just say, we don't get along, I want to rent to somebody else, like you can now with, say, a month-to-month tenancy, or just not renewing a lease. After a lot of lobbying, that was thrown out entirely, and the only language was left was saying that the evictions have to be done according to state law, which has been, of course, the law for a number of years. So we avoided that. I thought it was kind of ironic that if something like that passed, it would actually be harder to evict a tenant than to divorce a spouse, because for about the last 45 years, we've had no-fault divorce in Missouri, where neither party has to blame the other one for anything. You just say, we don't get along anymore. There's irreconcilable differences. So you could divorce a spouse for no reason, but you'd have to have a legal reason to throw out a tenant. So that did not happen. We're back to where we were to begin with on that.
And thank you all. And I want to thank all the voices and all of us in the industry that helped to get that out of there. That was a crucial victory. I mean, it was a big victory for us. And so that was something else that we were responsible for. And I want to pat us on the back and thank all the people at the table for that.
Now, the next very hot topic we had to deal with was screening issues and the use of prior criminal history and prior eviction history. And the first drafts were very restrictive, and we made quite a bit of progress on that. What the language says now is the landlord shall review additional information provided by the rental applicant, including but not limited to personal references, recency and severity of any evictions, recency and status of any evictions, and any actions taken by the rental applicant to resolve past evictions. So your only duty in reviewing an application is to review any material the tenant might provide to you. Now, that doesn't mean you have to be swayed by that. If someone has a couple of evictions on their record and maybe some jail time, something like that, they can come in and say, well, yes, I finally paid off those evictions. I don't owe any money to any other landlords. I successfully completed my criminal probation. I'm now a member of the church choir. Here's a letter from my pastor, all this sort of thing. The landlord just has to review it. It doesn't have to change your mind. You can say, thank you for the information, but we're still not going to rent to you. You do have to have some standards, and this is something I've been recommending. If you've ever attended any of the crime-free classes I've taught, you'll have heard this before. I've always recommended some sort of criteria, particularly in regard to criminal background, of how far you want to look back on any particular type of crime. So you could say, if you've committed a crime against persons within so many years, we're not going to rent to you. Crimes against property, drug crimes, sex crimes, whatever. Because then you are basing that on the recency, nature, and severity of the offense, which is all you're required to do under the ordinance. And you can make rules like that also regarding evictions. Has the person been evicted before? Did he ever make it right with the landlord? Does he still owe money to previous landlords? Those are the kind of things you can review. I think there's two ways that you can be caught violating this part of the ordinance. One is if you have some kind of blanket prohibition, like some properties have had in Kansas City, that say, if you've ever been convicted of a felony, we're not renting to you, period. That's a clear violation because you have not reviewed the recency, severity, or nature of the previous offense. So a blanket prohibition would be, I think, a clear violation. Also, I suggest you never, ever, ever reject someone on the telephone. I expect that after June 1, some of you will be receiving calls from testers. And you will probably get calls that say something like, yes, I just got out of jail for child molesting, and before that, I was evicted 3 times. Will you still rent to me? No matter how heinous a history you might hear over the telephone, your answer should always be something along the lines of, you need to come in and fill out an application. We rent to anyone who qualifies under the fair housing laws, something very non-committal like that. But never, ever, ever say no over the telephone because you have not reviewed all the circumstances of this. You've not talked about the recency, severity of the nature of the offense, the status of the evictions, any of that. So the answer to any question over the phone about who you rent to or not is, we'd love to have you come in and complete an application. You never reject anyone over the phone. I know of one call that's come into a property that we suspected of being a test of some kind. The caller said, I hear your property is on the list of gay-friendly property. Is that correct? Well, the manager never heard of any such list. They never had any particular policies on that issue. And she basically gave the right answer. Well, just, I don't know of any list, but come in and we'll take your application. I think what the tester was shooting for was something, hoping the manager would say something like, oh, we're not on a gay-friendly list, we're not gay-friendly, meaning we never signed any documents, we never got on a list saying we were. So then they could file some kind of complaint saying they're anti-gay or something. But anyway, I think those are the kind of things you're going to have to be watching for, particularly after June 1, when a lot of these new restrictions go into effect.
Are there any questions on that part, Robert, so far?
Yes. Beth says, thanks, Bob. Harmony Brown says, if you use sites like myrental.com that give a tenant score based off credit score, criminal history, and eviction history, and you use that as a defense to not rent to them, even if you're aware of their crimes and aren't comfortable, and you use the tenant score from the website to deny renting to them.
I would think so. People have been using credit scores for a long time. And that's always been kind of a good fallback in that, you're getting a composite score, which relies on a lot of different factors. And if you have a definite cutoff line saying we don't rent to anybody below this number, that I think that would be good, something good to rely on. I think you do need to look at how that score is put together, because if they have a policy that says something like, anybody who's ever committed a felony has a negative score, I'd be very careful of that. You can't use organizations like that or screening services as a shield unless you really know how they put their criteria together.
And also, I was just going to add, if you're using the score to reject somebody, that's valid. But if the person says, but let me show you my criminal history, go ahead and accept whatever they want to show you. Even though you're going to be rejecting them based on some other objective standard, you always have to accept whatever they're willing to show you.
Take their documents and review them.
And in any event, right? Because remember, the mayor said one of the goals of this is just to get us to have a conversation with the tenant before you reject them, basically. And so even if you use the credit score and it's from a reliable source, one would think that you'd have a conversation, like you were saying earlier, Bob, where you say, let's talk about it, come in and fill out an application. Even if you're going to use that credit score, we must at least talk to them.
Yes, and there's no reason the conversation can't end with a no.
Right.
And I would add that if you're defaulting to use some type of scoring system, you need to make sure that you're using your scoring system and you have the same requirements consistently, and you're not just applying a scoring system to somebody who has a criminal history that you don't necessarily like. So we need to be consistent in our application for fair housing.
So how does that look? How does that look?
Well, one of the problems I see here is that for the decades that we've been involved in housing, whenever we've done a fair housing class, we've been telling people all the standards have to be objective, no exceptions. You apply the same rules for everybody. I think anybody that's listening to this knows that's what we've been taught for decades. Here we have a very subjective element has been thrown in here when you talk about reviewing other materials. What's your standard on that? Do 2 pastor letters come ahead of 1 pastor letter? Is a letter from a pastor better than a letter from an employer? How long has this person been employed? How do you set standards for that sort of thing? If you accept a letter from a pastor from one person, the other person doesn't have a letter like that, are you discriminating on the basis of religion because he has a letter from a clergyman? We're getting into very subjective ground here, and I don't know how all that's going to shake out. That's why I say, again, all you have to do with these extra materials is to review them and still objective standards.
And so as a real estate agent, we're always taught to be prepared for the day where you may find yourself in court. And so as a landlord or housing provider, if I'm hearing all of this and I must be subjective, if I'm creating from scratch today to prepare for June 1st, what does my paperwork look like? If I wanted to have an internal form, an administrative form that I use to say, you know, if a tester does this, or if someone comes to me and says, okay, Stacey, you're in violation, we're filing a complaint against you. What documentation can I have set up that I can show, yes, I am consistent across all applicants. I follow this, and this with every single person. How does that look?
Are we still working on an 11:30 deadline, Stacey?
We're working on keeping us out of jail. That
Yeah,
deadline.
I think that's a topic for another whole class.
Okay.
I'm sorry. Yeah.
But generally, we do need to have something in place that we can use to say I'm consistent with every single person, and here it is.
You have to do what we've been talking about ever since the Fair Housing Act was passed: is documentation. Why, you know, what did you consider in making this decision, and be able to show that it wasn't based on race, religion, sex, etc. As far as these new city requirements, I think you might want to add some standards, like as far as criminal history and eviction history. What are you going to pass? What are you not going to pass? And something where you can say, we applied this to everybody who came in our office, just like you've been.
Okay, that's what I was looking for.
I want to pipe into your question, Stacey. From my days as a multifamily property manager, it comes down to, as Bob said, document. We had telephone phone call logs. We had application logs. If anybody who's ever been through a fair housing lawsuit knows that they've had to pull all their applications for the last 6, 12, 18 months, 2 years, whatever. So it's just document, but you have to be able to pull that information. And while we're holding all that information, we have to be careful with how we're holding all this sensitive information for all these people that we've received applications on.
Okay, good. That's all. I'm just worried about jail time, fines, and being sued, and just trying to protect that. So that answers the question. So I'll turn it back over, Bob, and I'll be quiet.
I'll bake you a cake with a file in it, Stacey.
I appreciate it. I may need it.
On the topic, since we kind of did drift over into fair housing here, there's some elements here in the new ordinance also. They have expanded the number of protected classes that are covered in Kansas City. Now, the federal fair housing laws have not changed. Under federal law, there are still just the 7 categories. But in Kansas City now, as far as an ordinance violation, for some reason, and I don't know why this is, probably something that's politically correct, they don't talk about protected classes, they talk about protected traits. I don't know if that changes anything. But some of the new protective traits that are covered in Kansas City are sexual orientation, gender identity, gender expression, or being a victim of domestic violence. You can't discriminate against any of those groups. Complaints will be referred on discrimination, will be referred to the Director of Health. What they know about fair housing laws in the health department, I don't know, but I guess we're going to find out. Let's see. Oh, another topic that came.
Bob, I was just going to say, we requested repeatedly that they define those new traits, especially gender expression, and they refused to do so. So I don't even know that would pass constitutional muster, because it doesn't really tell you anything.
Yeah, I don't know if those cases, those terms have been defined in other case law or what, but that basically says, however they're dressed, whatever they do when they come in, that's is not grounds for discrimination. Okay, the next topic is
Bob. We have a question.
Yeah, sure.
Must we provide a denial response within a specified time period, as discussed previously at the mayor's meeting?
Giving the reason for a denial within a certain time?
Yes.
I don't see that in the ordinance. I don't know if, Dan, did you see anything like that?
There's not. I don't think there's anything about that.
A question that I've been asked many times over the years is, do you have to give a reason for rejecting somebody? And the answer is no. I don't know of any law that requires you to do that, but I think it's a really bad idea not to. If you're doing business with somebody and you apply for a loan or anything like that, and they deny it, the first thing you're going to ask is why. And if they don't give you an answer, you're going to suspect there's some reason they're not telling you. And I think a tenant applicant is like anyone else. You rejected me and you won't tell me why. There must be something wrong here. And then they go running to HUD or the city and they file a complaint against you. And then you do have to say why you rejected them, that it was some reason that's not discriminatory. So rather than invite all of those headaches, just say, it was because of your criminal history, it's because your eviction history, whatever, as the information we got from so-and-so, you got a low credit score, whatever it might be, say it. Now, I don't want to get too far off our topic here, but if you have information, if you're denying an application for a reason you got from a credit report, you have to give them what's called an adverse action notice, which is required by the Federal Fair Credit Reporting Act, if it's based on a credit report. But again, I don't want to go down that rabbit hole right now because that's not what we're here to talk about today. Okay, next topic on my outline is inspections. And this is something where there's a lot of back and forth. The original draft would have required a 48-hour notice to enter a property. We got that cut down to 24. And there's no notice needed for an extreme hazard. I don't know I've never heard of the distinction between a hazard and an extreme hazard. I'm reminded a little bit of the Jack Nicholson scene in For a Few Good Men, where he's asked, was he in danger? Yes. Grave danger? Is there any other kind? Yeah. So an extreme hazard, is there any other kind? I don't know. But you can enter a property with no notice for an extreme hazard. There's still a problem with, well, first of all, the topics, the reasons you can get into a property are a little more limited than what we have in most of our leases. Now, there is kind of a catch-all safe harbor here, which is if you get written consent from a tenant to enter at any time, nothing else applies. Once you've got written consent, nothing else matters. But if you don't have written consent and you want to get into a place into a unit to do some repairs, for example, you have to specify the date and time of the intended entry, the identity of the person or persons to enter, and the reason therefor. Now, we wanted to be able to just say, look, on a Tuesday morning, we're going to send a plumber over to fix the toilet. But here, they still have the requirement to give the date and time and the identity of the person. Now, I think this is going to get into one of those areas. I don't expect landlords to really get into trouble for this because there are times you just cannot reasonably comply. If you call a plumbing service to come over for service, they may not be able to tell you which guy is going to be available at which time. How often have you called someone for service and been told they'll be there between noon and 5? If that's all the information you have, that's all the information you can provide. Not to mention, if you have a problem where, again, you have ABC Plumbing is supposed to come out tomorrow morning, and they give you a call early, they can't make it, all their guys are busy, they have emergencies, so you have to call somebody else. Well, now you no longer know the name of the person, and the notice you gave isn't any good anymore because ABC Plumbing isn't coming. So you call XYZ Plumbing, and they're going to come over. But do you have to give another notice now? Seems a little bit ridiculous. I find it hard to believe that a municipal judge is going to gig somebody for sending over a different plumber, but that's what the ordinance says. But
Hey, Bob.
again, once you get written notice, you're good. Yeah.
Lauren asks, would an email or text constitute as written notice? Assuming you text the tenant and say, hey, we'll be by tomorrow, and the tenant replies or doesn't reply.
I would say so, yeah. texts and emails or writings.
And there should be something in your lease that allows you to communicate through text with the tenant.
Another very hot topic was what's called source of income discrimination. Again, this is a national thing. A lot of states and cities are wrestling with this. And it sounds, if you're not familiar with the industry, it sounds pretty rational. Landlord, if the tenant can provide money from any source, from any legal source, why shouldn't you count that? Well, what that's really about is requiring landlords to take Section 8 and subsidy programs. Otherwise, you're discriminating against source of income. So, fortunately, I think this alone was worth all the effort that was put into it. In the source of income language, the same language is in there, but that you have to accept any sort of legal source of income. But there is language that says, in no event shall an owner be compelled to participate in an otherwise voluntary benefit or subsidy program. So right there, that's clear language. You do not have to sign up for Section 8 or any other subsidies. So what is left of the language in that paragraph? I think it basically says any kind of legal source of income you have to include. If it's maintenance, child support, any kind of welfare program, any dollar they have coming in, you have to count as their income. I think a question that may come up, something I was asked by an attorney within the last few days, suppose the applicant's Uncle Joe comes around and says, I'm going to take care of my family here, and if he's ever short on the rent, I'll take care of it. Or says, I'm going to pay $500 of his rent every month. Or you have somebody comes in and says, I need an apartment for my honey pie, and I'm going to be paying the rent, but the lease is going to be in her name. Can you count that? I would say yes, if they actually sign a document, some kind of guarantee of performance, as a guarantor, co-signer would. And if they're on the hook for it, if that's something you can count on, that they're legally obligated to do, I would say you have to count that also probably. Now, again, as I've told people in classes before, if you're going to have a co-signer or a guarantor, you do the same screening on that person as you would for that tenant. Because if you're looking to that person to be the source of the money, you need to know it's there. Does he have credit? Does he pay his bills? Does he have the income? So that, I think, is what's left of source of income.
And if I could say, you're kind of humble and modest about it, that was a big deal getting that removed. And I will trace that back to the time when we had the second Housing Committee meeting on this ordinance and this Bill of Rights, where we filled the room with housing providers. We were in full force, and it was during that meeting when they heard from us, saw us there, that this particular provision requiring us to accept any source of income, but that was removed. And so that was the industry speaking with one voice and very successfully. And I think it made a huge difference. It'll make a huge difference in our ability to screen our tenants and choose who we want to live there based on other qualifications.
We have another question for screening. How do you handle not permitting pets without discriminating, especially when dealing with service dogs and emotional support pets? And then I think she also wants to know, would the same apply to anyone on a Section 8 voucher?
That's really way off the subject of this ordinance. And again, the time it would take to go into that, we don't have a lot of time on this. So if it's all the same, maybe that individual can contact me offline sometime or give a call. But that's a complicated subject. Generally, if people have disabilities and you can get a letter of verification they have a disability that requires them to have some kind of animal, then of course you have to waive the no pet rule. That's the nickel answer.
Thanks,
And if I
Bob.
can just jump in, I know you need to finish up, but just the thought here, and I haven't talked to Robert about this in advance, but Landlords Inc. may hold these workshops in the future. And there are a couple of topics today that we didn't have time to go into. So maybe we collect, and if people have ideas for things that you want to hear in any kind of workshop, maybe in the chat, we can collect some of those topics, and then we'll revisit it as Landlords Inc. to see if we may be able to host a workshop or any of those other groups in the industry that are at the table here that may choose to do that, we'll at least have an idea of what people want to hear about.
And
Okay,
I can
Bob,
tell you that none of that has been affected by this ordinance at all. One last thing they have in here, which is a little bizarre, is in the section dealing with retaliation. You cannot retaliate against a tenant for making a complaint or for participating in a tenants association or for bargaining collectively. But there's no requirement that the landlord bargain with the tenants. Collective bargaining is an old phrase, of course, it goes back to labor law. And the labor laws in this country, I think, are somewhat the size of the Bible, give or take. So to just put a little phrase in an ordinance that says the tenants are allowed to bargain collectively, I'd put that in the category of totally meaningless. One other thing that was done, I guess a victory for the tenants group, was the creation of another bureaucracy, a landlord-tenant department to deal with violations of this ordinance. That did get funded, I understand, to the tune of about $385,000. It is unclear yet exactly what they're going to be doing. They do have the authority to update the Tenants' Bill of Rights. It says it can be updated semi-annually. So whatever other rights they come up with, they can issue those, which, again, will probably not have any legal effect. I do think we need to talk about a few issues that are still going to be hanging out there. There are at least, if you're a landlord in Kansas City, there are at least 3 different definitions of what a tenant is. I would say the one that controls is the one that's under state law, which is section 441.005, which says, this sounds like common sense, a tenant is a person who occupies the premises with the landlord's consent. That's pretty straightforward. In the new ordinance, however, in different places, there are actually 2 different definitions of tenant in this document. The first one says a tenant is a person, is a purchaser under a contract for deed, is a tenant. That is contrary to years of Missouri law and real estate law that says a purchaser under a contract for deed is an equitable owner. He is not a tenant, unless you have some language in there that says otherwise. But so that part of the definition of tenant, I think, is directly contrary to state case law for decades. Also, a tenant is a person other than the legal owner occupying a building or portion thereof as a rental unit, which means anybody who happens to be on the property other than the owner is a tenant. That conflicts with the state law that says occupying the premises with the landlord's consent. So that's problematic. The other definition of tenant is a little more consistent with state law. It says under section 35 of the ordinance, a tenant is a tenant, a subtenant, sublessee, or other person entitled to the possession, occupancy, or benefits of a rental unit. So 2 of the definitions definitely say you have to be there with the landlord's permission. One of them doesn't. So it'll be fun to see how the courts wrestle with that. Another real problem with the ordinance, what happened here, and this is, we get into commentary here rather than law maybe, but there was such a fight over major portions of this ordinance, and there was such a rush by the city to get it passed, that a lot of the polishing and fine-tuning that you would often find done on legislation wasn't done. That's why you have a couple of very problematic typographical errors. You have these different conflicting definitions. And you have, I think, some constitutional problems. For example, one section says you're violating the ordinance if you are an owner and you violate any of the state landlord-tenant laws. No restrictions on a tenant. If a tenant violates the landlord-tenant laws of the state, he's not violating a city ordinance, but if an owner does, he is. I think that is a clear violation of equal protection of the laws. That may not last too long. One other thing that happened is in the creation of this bureaucracy I mentioned, it also created an appeals board. Now, here's how the appeals board is going to work. It is going to consist of 7 people, one of which is a representative of the housing providers, one is a representative of a tenants organization, one is from a neighborhood association, and 4, a majority, are simply at large. And all of them are appointed by the mayor. Now, so even though you say, well, we have one representative on the board to represent us, no, you don't. You have someone who's picked by the mayor to represent you. It's not like Mare and Landlords, Inc. and the Apartment Association get together and elect a representative. No, the mayor chooses who your representative will be. It's kind of like the problem the colonists had with King George III when the British told us who'd be watching over us in the House of Commons. We don't really get to choose our own representative. Another problem with that appeals board, it says that each member shall serve for a period of 2 years. However, it also says the members can be removed on written notice from the mayor. So apparently, the service on this board is solely at the pleasure of the mayor. So that's the board you will be appealing to if you have, if you get cited by this department.
And we saw how that went when they appointed the Healthy Homes Board. The landlord representative from there was actually from a social service organization, and I believe only showed up to less than half of the meetings they held.
And the mayor is the chair of the housing committee and was the co-sponsor of this particular legislation that we're talking about. So we know what he thinks about us in the industry. So that's a concern.
We have a couple more questions, Bob.
Okay. Go ahead.
Betsy asks, can you advertise a rental as not on the Section 8 program?
Sure. Because you're not under the obligation to be in Section 8.
Shelley asks, can we collect pet fees for ESA animals?
I still say no. There's some conflict about that, but it's my gut feeling is just it's not worth the hassle.
For those of you listening, ESA is emotional support animal.
Yeah. I wouldn't bother with it.
Any other questions, folks?
If I could ask then, if there are none, if anyone has other topics that have come up, if you please be sure before we close out to put those topics in the chat, so that way we can see them and then we can consider if we're going to do anything as Landlords Inc. And then we'll communicate to you, have your email address, and we will be able to communicate to you. And then also for everyone, just to keep track, like I mentioned earlier, some of those investment groups, those other investor type and real estate groups that are on Facebook that are engaged to the topic, networking and sharing great information, to please find those. And the KC Regional Housing Alliance also has a Facebook page. And then Robert, you're going to talk about the video of the recording of this and where that's going to be before we wrap up, right?
Sure, we will post parts or this recording on our Facebook page and probably on our website as well. I do have a couple more questions that have come in I'd like to get answered. Michael says, can we accept, this is a good question, I struggle with this sometimes too. Can we accept applications for a specified advertised time period to gain the optimal applicant? e.g. now accepting applications for XYZ rental for 14 days for this property in order to deny all other. And I have challenges with that in first come, first serve. You get an application from somebody and you'd really like to kind of mark it for another week or two to continue. So how should we deal with that?
Okay, I'll jump into this one. I remember, this goes back some years ago, but I was instructed that, at least according to HUD regarding fair housing, there is no such thing as a better applicant. Now, we all know differently, but we don't work for the government. According to HUD, a tenant is either qualified or not. So if you require someone to say their income has to be at least 3 times the rental, and one applicant comes in and he has 4 times the rental, and another one has 5 times the rental, the one with 5 times the rental is not a better applicant. He is qualified, as is the fellow with 4 times the rental. The first one that applies, first come, first serve. Whether you could actually get in trouble for going another route, I'm not sure. They'd still have to prove, as far as a discrimination claim, if they were in different groups of some kind, they could possibly make a complaint. But I've never actually seen a fair housing complaint based on that. But you never know.
Thank you.
Anyway, that I think is the approach of HUD, that you're either qualified or not, you're not better qualified.
Take the first qualified applicant is what you're saying.
Yeah, I think that's what HUD likes to see.
That's
John
the safest
says,
course of action.
I'm sorry,
Beg pardon,
Dan, I spoke over you.
That's right. I was just going to say that's the safest course of action, because otherwise you're going to have to explain why you didn't choose the other person.
Thank you. John says, just to be clear, for long-term existing tenants, when they renew their leases, will they have to comply with all of these requirements?
Yes. Well, if it's a new lease, the new restrictions will apply.
What about leases that just auto-renew? Is there anything we need to be updating in them?
Well, I guess you could argue that it's the same lease that was entered into before June 1, and that the new restrictions wouldn't apply.
If they're not signing the new lease, you probably don't have to. But if it's renewing and there's a signature involved at that point, go ahead and give them the disclosures and the Bill of Rights.
Okay. I see Sam Alpert with Heartland Apartment Association. He has something. Robert, do you see a question from Sam? I saw you raise his hand.
No, I don't. Oh, there, hang on a second. We'll get him live here, I think. Sam, go ahead, you can speak. Welcome.
He's muted. Sam is muted.
Okay.
There he is. Oh, Sam?
Oops.
There he goes.
Sorry.
Oh, now it's muted again.
Okay, now it should be. Can you hear me now?
Yes.
Yes. Hi, Sam,
okay.
welcome.
Hi, how are you doing? First of all, Bob, I want to thank you for broadcasting from the space station this morning.
Well, that answers. There's a question from Attorney Carrie Kincaid as to whether I really am in outer space, and yes, Carrie.
That's a real commitment, I have to tell you.
Santa Claus play just went by a moment ago.
One of the overriding issues right now is that the whole world has changed since.
Oh, we just lost him.
We lost him somehow.
Ah, that was going to be great. Here he comes. He's back.
I upgraded him as a panelist. Maybe we'll see him now.
He's muted.
And while he's doing that, Sam is the executive director of the Heartland Apartment Association, which represents over 90,000 rental units in our region. And he's a very integral part of our alliance, our KC Regional Housing Alliance. And I think he's unmuted now.
Okay.
Sorry, Sam.
Can you hear me now?
Yes, sir.
All right. So Since we started these discussions, certainly the world has changed a lot. And I think just as a practical matter, and I want to, reiterate the importance of documentation and the way we treat our tenants. We have to be very, very consistent in everything we do and make sure we're well documented. As a practical matter, I really think that part of the discussion going forward over the next weeks and months and maybe years is going to be where the funds are going to come from to enforce compliance with all of this. It's probably not going to be, while we talk about basic services for the city, police, fire, health, and safety are going to be, number one priorities. But in terms of, worrying about, how many inspectors are actually going to be going out and doing these inspections, whether they're originated by the tenant or not, or there's some kind of systematic inspection being considered. I don't see it. I don't see it for a while. I just think it's something we need to focus on, making sure that we are using best practices. That's what we need to focus on. Right now, I'm thinking that the emphasis is going to be on how, and it goes back to, our emergency assistance initiatives that we've taken as a group. Where's that money going to come from? We thought that the city was going to be a major funding source, I think, for what we were proposing, and I don't see that at this point. So I think there's going to have to be some revisiting those issues.
Well, we all remember that when they were discussing healthy homes, one of the goals was to inspect all the rental units in Kansas City, which we knew wasn't going to happen. As Dan pointed out, there hasn't been a permit issued yet based on that kind of inspection. They're still all just complaint related. The ultimate limitation on government is money. Just taking Kansas City an example, if people are unemployed, they're not getting paid, they don't have earnings, so they aren't paying an earnings tax. There's a real limit here as to what the city's going to be able to enforce. There were, as of Wednesday, the numbers I heard just 3 days ago, Kansas City had 12 deaths from the coronavirus, but 57 homicides. So how much time they're going to spend cracking down on landlords is probably a good question. I read recently a couple of universities that are laying off faculty. So as far as the ability of the city to really crack down on landlords and enforce all of this, are they going to come out and send people around because you didn't give proper notice of when the plumber was coming? I agree with you, Sam. I just don't think it's going to happen.
And if I can mention something too, Sam, I'm glad you mentioned that in the city and funding. As we know that during this time, and I know we're trying to wrap up here, but during this time we are subject to hearing about the rent strikes and the cancel rent, the zero rent that's happening not only nationally, but it's happening here locally. And so that is a big concern, where you have the KC tenants and social movements to tell people not only to not pay your rent because you can't, but don't pay your rent in solidarity with our movement. And their movement is to transform housing in general. They're against private property rights. But the point is that tenants nowadays need to find a way to shelter in place. As Derek Ramsey says, you can't shelter in place without shelter. And so we've been painted in many ways as being the enemy. In this particular case, we've gotten the narrative, our KC Regional Housing Alliance got the narrative out that we care about tenants, we care about housing people and securing people and sustaining them in their housing during this time in particular. Along those lines, our KC Regional Housing Alliance, we proposed, and like Sam mentioned, an emergency rental assistance program under the title of eviction prevention. The way to prevent evictions is to pay the rent. And so what we propose to the city, and our group is not just Kansas City only, we're regional. So it's not just Kansas City, we have other cities in our metro that we are working with legislation. One of the things we propose is that program, and we're working to see how that's going to look. And I will tell you that the city has money from the federal government through the CARES Act and through the COVID response. There are dollars available, and some of those dollars are going to rent assistance. So what we're doing is we're encouraging tenants who may not be able to pay the rent because they lost their job to apply for some of that funding. And we also know that the unemployment has been expanded. And so a lot of people we're hearing are making a lot more unemployment than in jobs. So there's no reason for them to they should pay their rent using some of the resources out there and apply for some of that aid, because it is coming to our city. We got $2.2 million in the city from the federal government for rental assistance and other things related to COVID. Those dollars are on the streets, and through the United Way, we can point people there. And the city is also working to issue grants too. And so the money is there, and our tenants do need to be reminded that they need to work out repayment plans with us. If you can't pay the rent, we're not talking about evictions at all. We want to work with them. We want to point them to resources, but we also need them to communicate with us, work with us, so we can come up with some kind of mutually agreeable repayment plan. And then we don't have to worry about, like Dan was talking about, the evictions, and that KC Tenants is trying to rile up people to say there are going to be tons of evictions hitting the courts when the moratorium is lifted. Only if they're successful in telling people not to pay their rent will people be evicted. So we need to be careful to get our positive message out there and encourage people to look at resources.
Agreed.
If I can interrupt with a little bit of good news, Governor, I don't know if all of you are aware of the response that the governor gave to the Kansas City Tenants Organization. They proposed some kind of statewide moratorium on rent paying and evictions and all of that. And his response was basically, number one, I'm not going to sign an order saying that every tenant in Missouri can stop paying rent. And number two, I'm not going to tell the courts how to deal with evictions. Evictions are court matters, and I'm not going to interfere with that. So
it's something they don't know. He's a former landlord. And so I think that works in our favor. And I know that they served an eviction notice on the governor's mansion, which is probably not real productive. And he, as a matter of fact, has sent $9 million from the state across the state for for rent assistance. So his response is basically the right response. Here are funds, pay your rent, stay sheltered in your home, and let's keep those families securely in their homes, as opposed to worried about evictions, which we're not as a group.
Hey, I'd like to go back to the follow the money situation, back to Sam's comment. I just want to point out that the Healthy Homes has generated a ton of money. What was it? They recently borrowed money from Healthy Homes to sponsor to loan it to some other program.
For the hotels for homeless people.
Oh, okay, right. No, that it seemed appropriate.
Right.
There was another loan of that money. Did it have to do with the election or something? They borrowed some money from the Healthy Homes Fund for something unrelated. So it is generating some money for them to misappropriate.
Right. Okay. And so we just have to be careful. I'll just say, I think we're probably ready to wrap up here. And as we're wrapping up, please know that the KC Regional Housing Alliance, we're looking at legislative policy. That's what we do proactively, as well as respond to what's out there. That's how we were formed. And we're an alliance of all of these various investor and real estate groups, speaking with one voice, property managers, investors, realtors, and landlords. We're all together with one voice. And so you're now part of us, and we will stay in touch with you. And please remember the Facebook page for KC Regional Housing Alliance, as well as the Landlords Inc. Facebook page, which is where Robert, I think, said that this recording will be, so that we can share with other property housing providers and landlords out there to make sure they have the information that Bob and Dan so graciously shared with us today. And we thank you both for taking your time and using your expertise to research the laws, and you were involved from the beginning in shaping them, of course. So your time there was appreciated, and in researching for today so that you can share with us as a community. We truly appreciate that. And then we will be back, and we see some of the ideas in the chat room for some topics. And so Landlords Inc. will look at that, and we will be back in touch with you. Any final thoughts before we let people go and enjoy their day now that we're kind of out of the the shelter in place and people want to probably enjoy the weekend. Any other final thoughts from any of the other, any panelists?
Everybody stay safe and well. Everyone stay safe and well.
Okay.
Thanks, Sam.
And please, and visit the Landlords Inc. Facebook page and the website. If you want to join Landlords Inc. To get access to the forms that will already have the things that we talked about already incorporated in, visit the kclandlords.com website. And other than that, Robert is president of the organization. Do you have any parting words, and then we'll finish?
Stacey,
Go ahead.
can I put in a plug for the crime-free class?
Oh,
Oh, yes.
if you would. Let's do it. That's important for property managers and landlords.
We skipped a couple because of the virus, but our next scheduled crime-free multi-housing class is September 9th up at the Police Academy. If you haven't been to it, it's a great class, all-day class on landlord-tenant law and crime prevention for free with lunch included. There is such a thing as a free lunch. If you want to get some specific information and register, go to the website kccrimefree.com. Thanks a lot, Stacey.
Okay, and thank you. Robert, you want to wrap us up, or Dan, any
Yes.
final words?
Some people have been asking if this has been recorded, and it has, and it should be available on Landlord's Facebook page shortly.
Or, yeah, right. Okay. Or at some point within the next few days, if nothing else, right?
Yes. I just want to thank everybody for coming. Thanks to all the attendees. We had some great questions. We had a great conversation here. As Stacey said, we'll take, if your questions didn't get answered, we'll take some of those other questions for different topics and perhaps look at doing a webinar that marijuana in our homes might be an interesting thing to talk about sometime soon.
And then also thank you for getting the word out to Mary, M-A-R-E-I, the Mid-America Association of Real Estate Investors, Winvestors, Bridge Real Estate Investment Meetups, and KC Regional Association of Realtors, Landlords of Eastern Jackson County, and the Heartland Apartment Association. So thank you all for helping us get the word out.